So, good morning, good afternoon, good evening, depending on where you are joining us from. This is the Mayor Brown webcast. You are either joining us live or you are joining us in a rebroadcast. We are going to be talking today about U.S.-China relations, really focusing on Hong Kong as a microcosm and as it impacts businesses, whether U.S. or other international businesses in Hong Kong, doing business in and around Hong Kong with all of the recent developments. I have with me today two senior partners from Mayor Brown, Thomas So and Tamara Solomon. Thomas So is a partner in Mayor Brown's Hong Kong office. He is in the Litigation Dispute Resolution Department. He is the former president of the Law Society of Hong Kong and a member of the Chinese People's Political Consultative Congress. He's obviously engaged in a lot of China-related matters and is very active as an arbitrator and a mediator. Tamara Solomon is based in Washington, D.C. He's also a partner in our Dubai office. He's the global head of the export control and sanctions practice. He is very much involved with national security, regulatory, finance, and technology trade sanctions space. I welcome them both. I'm Susan Schwab. I am a strategic advisor in the Washington, D.C. office of Mayor Brown, formerly the United States Trade Representative. So there is a great deal going on in U.S.-China relations, but it really has impacts all over the world on companies doing business in and around Hong Kong. And judging from the many different firms and governments that have signed up for this webcast, we want to cast an equally broad net in terms of our conversation today. We're going to be talking about practical implications of what is going on, and what we're going to try to do is to take a look broadly at what is going on and try to differentiate between the noise and the laws and the press releases and what the application is of the actual laws and policies and regulations and threats and threat mitigation opportunities for businesses. So let's get started, Thomas and Tamara. Thomas, let me start with you because you just returned from Beijing. You attended the Chinese People's Political Consultative Congress, and that must have been fascinating. And I suspect that the national security law was quite a topic of conversation. And the decision to impose that on Hong Kong obviously has been a focus of a lot of attention, not just in Hong Kong, but worldwide. So maybe you could start by telling us a little bit about that law as it's being drafted, and why that is being imposed on Hong Kong and what some of the broader activities are and implications might be.
Right, thank you, Susan. Yes, the national security law has been very topical and hits the front page of every newspaper in town here. The background of this piece of legislation is that over the past year, there were activities in Hong Kong that Beijing found that there's suggestion that the violent protests that have been happening over the past year or so were somehow driven by pro-independence forces and is believed to be supported by foreign pro-independence forces. And considering that Hong Kong itself is a special administrative region of the People's Republic of China, under the basic law, which is the so-called, people would like to call that the mini constitution that governs Hong Kong. Hong Kong has a constitutional duty under the basic law to legislate and outlaw certain activities for the purpose of protection of national security of the country. But after the handover, over 23 years has gone by. Hong Kong has not been able to legislate over those activities. And as a result, and in light of what happened last year, Beijing saw that there is a lack in the system that the Central People's Government set up for Hong Kong Special Administrative Region back in 1997, when the Special Administrative Region was formed, that there is a lack in the system in protection for the national security for the country. And as a result, it decided two weeks ago in Beijing that it would, the National People's Congress, which is the highest authority in China, decided to authorize its standing committee to draft a piece of legislation to protect national security of the country and make it applicable in Hong Kong. Now, that gave rise to some controversies because some people thought that this should be the job for Hong Kong Special Administrative Region because under the Basic Law, there is such a provision. Now, but constitutionally, under the Constitution of People's Republic of China, the National People's Congress does have that power to do that. And given that it touches on the national security at a national level, it is the duty of the state, which is China, to take steps to legislate it. And as a result, the decision was made, and the Standing Committee is now drafting that piece of legislation and has been consulting various sectors of the community. And the time frame that we estimated probably will come out in a month's time, which will reflect a piece of legislation to deal with specifically four main areas: secession, subversion, terrorists, and foreign interference into Hong Kong affairs. The legislation is not out. Everybody is waiting to see what it is like. And so all I can say now is we just have to wait and see when legislation comes out.
So that is very interesting. And I'm going to come back to you, Thomas, because in my experience doing business in China, Chinese laws are quite general. And who is interpreting them and how they are interpreted makes a whole lot of difference. So I'm going to come back to you after I ask Tamara a couple questions, because how you end up defining those four terms ultimately, I suspect, and who defines them will become very, very important. So let me come back to you on that. So Tamara, the lot of noise going on, a lot of activity in the United States, and a lot of confusion about what the implications are for not just U.S. firms, but other foreign firms with U.S. ties doing business in Hong Kong. And this seems to be changing every day, right? You've got different laws, you've got different authorities, you've got different regulations, you have different policies, announcements, and legislative proposals. So maybe you could start much in the way that Thomas did by kind of giving us the state of play and helping us to differentiate a little bit. How should we be thinking about these different buckets, if you would?
Sure. I mean, it may help just to sort of set the background in terms of the legal framework that governs the U.S. relationship with China, and what the Trump administration has very recently said that's creating, I think, a lot of attention. So the legal framework basically, we've set by the UK, the U.S. Hong Kong Policy Act, where the U.S. is committed to providing separate treatment for Hong Kong as long as it remains, quote unquote, sufficiently autonomous. And that's really been the bedrock of the U.S. relationship since the handover. A number of countries have voiced concern about the proposed legislation that Thomas just covered, including the United States, but the U.S. has now sort of gone beyond objection to announcing formal change in policy based on that law. And so now the United States has indicated that it will move towards eliminating the so-called separate treatment. That's gotten a lot of attention. The separate treatment has a lot of practical manifestations, more favorable treatment when it comes to CFIUS national security reviews from Hong Kong investors, more favorable treatment when it comes to exports and transfers of goods, technology to Hong Kong, and other practical benefits. Hong Kong is one of the few places in the world outside of the United States that has a dollar clearance system. So all of this sort of is important legally, but also lends a sort of vote of confidence in terms of Hong Kong's relationship with the United States and the West more broadly.
Do the buckets sort of sort out in terms of national security versus human rights versus sort of traditional trade policy, trade deficits, intellectual property? Is that a good way to think about it, or what?
Yeah, I think there are a few things happening at the same time here, and they're all starting to converge. So first of all, on Hong Kong itself, the administration has announced sanctions as well as sort of the removal of this separate treatment. And so there's a kind of a mixing of a change in the special status as well as some threat of a punitive measure. And the sanctions would particularly have a potential impact in the financial space and in the investment space. All of that is also happening at the same time as we've seen a significant change in the legal landscape relating to China more broadly. And that's not Hong Kong specific, but it would have a significant impact if the message now is that the United States is going to treat Hong Kong equally to China. That has a lot of implications in terms of the way in which transactions involving Hong Kong, investment transactions, technology transfer transactions, and financial relations would be handled, both in the United States and outside of the United States where there's a U.S. nexus. So I do think it's helpful to sort of break each of those down.
So Thomas, this is interesting. We get into this question of autonomy and U.S. legislation and policy sort of moving toward treating Hong Kong more like China, more like mainland China. So the question then becomes, in the new national security legislation law, is China going to be treating Hong Kong, or is security going to be treated in Hong Kong more like any other Chinese city, right? So going back to the question of secession, subversion, terrorism, and foreign interference in Hong Kong's affairs, who will be defining that? And how will that be treated? And then obviously, well, let's start with that, because I think that begins the ball rolling, right?
Right, yeah. From China's perspective, from the mainland China's perspective, by passing this piece of national legislation and have it applicable to Hong Kong itself, I don't think that China will look at Hong Kong very differently, as if it is another provinces or another city as in the mainland system. The reason is that mainland China and Hong Kong operates different systems. Now, mainland is a socialist country, and its legal system based in a civil law system. Whereas Hong Kong, because of its history, before the handover, it was governed by the British. It was a British colony. And so it inherited the British style of legal system, where it has a common law system. It has its rule of law based on the British system. It has its independent judiciary, and the transparency of the government, and generally the Hong Kong legal system has been accepted as a system where legal rights, all right, individuals' human rights, property rights, investors' rights are better protected and enjoy a reputation internationally. So that differentiate, that Hong Kong system, therefore, looking at it from that perspective, differentiate itself from the mainland system in many ways. And from China's perspective, even when they, in the report that they talk about the decision to authorize the Standing Committee to legislate on the national security law, the leadership emphasized more than once that they will abide by the one country, two system policy, and will act strictly in accordance with its own constitution and also the basic law to ensure that Hong Kong people's rights protected under the existing law will not be interfered. Now, the national security law, although it is drafted by the Standing Committee in China, in the mainland China, and as a piece of national law, if it is to be applicable in Hong Kong, it will be applied in Hong Kong strictly in accordance with the Hong Kong law, which I've just explained, which is based on a very different legal system than that in the mainland. And this piece of national security law, it is not the first national law that has applicability in Hong Kong. In the past, the NPC, National People's Congress, has passed similar national laws like the national flag law, the national anthem law, which are national laws and also were made applicable in Hong Kong. And when they were made applicable in Hong Kong, they were made adaptable to the Hong Kong legal system in terms of the way how the law is being enforced and the way how it is being prosecuted. And for cases that will be tried, it will be tried in Hong Kong, in the Hong Kong law system, which is very different from the same case probably based on the same national law, but dealt with in the mainland. So the short answer, I think, to Susan, your question just now, the autonomy that Hong Kong has enjoyed under the basic law is a high degree of autonomy. High degree of autonomy is not an absolute autonomy, and that autonomy was guaranteed under the basic law, subject to a condition that Hong Kong is part of China, and that Hong Kong is under the direct authority of the Central People's Government. So it is from that perspective, when you look at it, that the high degree of autonomy enjoyed by Hong Kong under the one country, two system policy. But when you have a national security issue that is a matter for the nation, for the country, so I think that the obligation to protect a country's national security interests, notwithstanding that we have two separate systems, but then the duty should be the same.
So let me do this. I'm going to move to, this is a good way of segueing into the question of risk. And I'm going to start with you, Thomas, and then go to Tamer for exactly the same range of questions. Looking at the four items in this new law that will appear in this new law, and obviously nobody has seen the final text. The national anthem law and the flag law, those seem to be clearer. But if you are a foreign firm doing business in Hong Kong, and you know that one of the do not items under the new national security law relates to, quote, foreign interference in Hong Kong affairs. That is a very, very general phrase that could be interpreted any number of ways. So what, if you were advising such a firm, what would you advise is A, the risk to the firm and its employees, its expat employees, its Hong Kong employees, and what might be done to mitigate or to guard against those risks?
Right, thank you. I think, you are right. The legislation has not yet come out. I think devil's always in the details. But one can actually look at the four main areas that the legislation was meant to outlaw: secession, subversion, terrorists, and then foreign interference. The secession part is very easy to understand. Secession is where you promote a split of the country. Like, for the past year, we've seen people coming out advocating independence, Hong Kong independence, right? So that definitely is something that one should avoid doing because it goes straightly against the idea falling within secession. Subversion, you overthrow the government, all right? So that's also quite easy to understand. Terrorism, very straightforward, violent, you throw petrol bomb with intent to overthrow the government. Now, foreign interference, the fourth bit, looking at the overall scheme of the legislation, I have a feeling that the foreign interference bit would have some link to the first three items. So meaning that from the perspective of a business, foreign business doing business in Hong Kong, if you ask me at this stage, of course, ultimately we will need to look at the law when it comes out. But at this stage, the interference bit that I think people should worry about, should concern themselves with, are activities that maybe a business might inadvertently get into involving perhaps their staffs in the secession, subversion, or terrorism activities. Now, sometimes inadvertently. The reason I say this is there might be an organization out there who say that they are organizing like community project, for example. But then at the end of the day, they might be organizing protests and things like that go to the secession, subversion, and terrorism aspect, and without understanding the depth of that activity, some business might, believing that it would be in the good cause of the community, maybe donate money or maybe encourage their staff to participate in certain community projects. They call themselves community projects, but then we need to find out more details. So what I can say to the foreign business at this stage is that, looking at it from that perspective, you need to be very careful in that kind of activities, and make sure that the company and also your staff do not fall into that category of activities that might fall within the national securities laws category.
Thank you, Thomas. So Tanner, there's a whole different set of risks associated with doing business in Hong Kong or in and with China and in Hong Kong increasingly. On the U.S. side, you started talking about the legislation that is on the books. There is new legislation being proposed. One example being that's gotten a lot of press recently, the so-called Hong Kong Autonomy Act, which is not law yet, but is under consideration. Maybe you can talk about the prospects of legislation like that and what the implications are relative to authorities that are already on the books, and the extent to which you see those authorities either on the books or prospectively, potentially being on the books, being used to impact business being done by foreign firms, including U.S. firms, Japanese firms, European firms, Australian firms, and others in Hong Kong? And what are the risks to those firms and their employees? And then as a follow-up, I'm going to ask you what might be done to mitigate or reduce those risks.
Okay, sure. Yeah, and yeah, I think you're right, first of all, to point to the fact that this is not just about U.S. firms and those operating in China or Hong Kong, but it really has broader implications outside of those borders. I'll touch briefly on the legislation piece, and then I'd like to talk about the sort of risk question. I think that's really where the heart of this lies. The Toomey Van Hollen bill, Hong Kong Autonomy Act, very recently proposed. In a nutshell, it would build on a law that was passed just a few months ago in November of 2019 in the context of the protests. And essentially threaten more significant sanctions against persons as well as foreign financial institutions, who the persons who would be viewed or determined as contributing to the loss of autonomy in Hong Kong, and then foreign financial institutions that may engage in significant transactions with them. I think the idea there is that there are a number of proposals like this. The president also mentioned sanctions as part of the use of sanctions as part of his announcement with respect to Hong Kong. But there is already a legal framework that would provide authority for the president to impose sanctions in relation to similar activities. The Magnitsky Act, Global Magnitsky Act would authorize that. I think just stepping back, it's clear that based on the president's announcement, the Secretary of State's announcement, this activity in Congress, both late last year and what we're continuing to see in terms of bills, whether this particular bill is passed or not, that the issue of Hong Kong and the sort of ongoing protests, this national security law, is going to continue to be center stage, at least from the American perspective. And so let's talk about what that means in terms of risks. I think on the sanctions front, because that's getting a lot of attention, what is the likely impact of sanctions if you're a business with significant interests in Hong Kong, or a business that's a significant trading partner? There's a broad range of possibilities. The U.S. has very, very significant sanctions authority that we see deployed in a lot of ways. One is limited, ranging from very limited to very extensive and rather comprehensive restrictions. Generally speaking, I think we think the comprehensive in the Hong Kong context is a very remote scenario. I think what we're likely to see is more limited, targeted sanctions and incremental sanctions in nature. So meaning, and I think that's borne out by the Secretary of State's statements that focus on, quote unquote, the decision makers, right? So targeting officials who are seen as having a role to play. I think the harder question, and an important question, is once those officials are designated, the bill that is being proposed and other existing legislation also talk about foreign financial institutions and others who may engage in significant transactions with those officials who are designated. And so that has an impact outside of the borders. I mean, if you think about accounts and assets that are held by those individuals, they could be subject to asset freezes. That would be the immediate impact of even a targeted restriction. And even exit strategies from an investment perspective. If you have dealings or holdings involving those individuals, investments that are custodied in Europe or outside of the United States, those could be impacted. And as an investor, the market for potential buyers would shrink if there's a designation of those people. So you have a couple of different risks in that space, even where we see limited sanctions and targeted sanctions being the most likely scenario. So a good thing to be doing right now from that perspective is reviewing sort of asset and account portfolios for politically exposed persons and sort of assessing the impact of potential sanctions, even in this targeted scenario. I think another, and this comes back to a comment you made, Susan, about noise, is for companies to have a process in place for monitoring these developments, because these are very fast paced and multi-axis developments, both legal and political, and communications flow, because there is a lot of noise out there, and it's important to sort of ensure that you can separate the innuendo and the rumor in both jurisdictions, frankly, from what's most likely to occur. I'll touch on one other, I think, important space outside of sanctions that we see having a potentially significant impact based on the president's statements, and that is the likely impact of export controls and sort of technology transfer restrictions. And here this comes back to what's been happening on China that has not been necessarily Hong Kong focused, but if the message is Hong Kong is going to be treated like China, one of the direct implications of that is that we will no longer separate Hong Kong from China when it comes to our national security reviews. When it comes to investors in the United States, we'll no longer separate them when we think about exports of goods and technology. So that has an immediate impact. I mean, there is an initiative, the Greater Bay Area Initiative, for example, that focuses on diversifying Hong Kong's place as a global financial hub to making it part of a larger tech startup ecosystem and a tech hub around the Greater Bay Area with parts of mainland China in the south. And so, immediately what's been happening in the past few years on the China front is that we are in a much, much more restrictive environment as a matter of US law when it comes to technology transfers to China. And a lot of things that could go to Hong Kong and can go still now to Hong Kong without licenses, without export licenses, would become subject to a much more restrictive regime. And even more restrictive than it's been, a few years ago. And so that has important implications, again, for the Japanese trading partners, European trading partners, not just US companies, because the law applies to the goods, it applies to the content, the technology, and not to equally, without regard for the nationality of the person. So again, think about startups in this space, think about investors in those startups. I think a good thing to be doing, again, is assessing the potential impact based on the technology and based on what the relations would be with mainland China, who would have access to that technology. And if the business case is based on the ability to continue getting access to US technology, whether it be from the United States or from trading partners in Europe or other parts of Asia, then you have to think about what would the impact on the business case be if that were to change and become significantly more constrained. So I'll pause there.
No, very helpful. We are going to be running out of time, so I'm going to make one point and then ask each of you a quick question questions that I get asked very frequently from clients. First of all, point, anyone who hasn't signed up for Mayor Brown alerts, a lot of this information and updates show up in the Mayor Brown alert. So if you haven't done it, do it. So Thomas, your last question, I get inquiries all the time about the unreliable entities list. Is there anything that you could share with us? Because I'm sure you get those questions too. We hear all the time about China being about to issue an unreliable entities list, who's going to be on it. Anything that you can share with our viewers about that?
Right, okay. Thank you, Susan. Yes, I think the Chinese government has been talking about this unreliable companies list for some time, although in fact there aren't very detailed regulations being passed talking about, for example, how to decide what kind of companies should go on that list. Although it is in the decision that for companies that are believed to pose a threat to national securities of the country, it is possible that for those companies, then they can be included in that list. But as to what kind of criteria in deciding when you can say a company pose a threat to national security, there aren't any clear regulations And similarly, there aren't any clear regulations to say what consequences will follow if a company is being included in that list. So at present, so it is still very unclear. I just told you all I know about that list. But on the national security law issue, I think that people should keep a close eye on the development. And when the legislation comes out, I'm sure that we'll be able to do some email alert to keep everybody informed.
Terrific. Thank you very much, Thomas. And Tamara, the other question we keep getting and we've gotten for the program today is what happens with the U.S. election? What are the implications of the U.S. election? What if Joe Biden becomes president? What if the Democrats take control of the United States Senate? Do you want to speculate about U.S. politics?
Well, it's dangerous to speculate about U.S. politics, but I'll take a crack at it. I think the election cycle that we're going into is really likely to feature both candidates jockeying over who is tougher on China. I think that is clear, including in respect of this Hong Kong issue. And you can look at Joe Biden's statement. I think just shortly before the president came out and made his statement on Hong Kong, where Joe Biden said that the U.S. should be leading the world in condemning China with respect to this Hong Kong security law issue. So I think you'll see more of that going into the November election. The other consideration that's important to keep in mind here is that there is strong bipartisan support in Congress around support around this Hong Kong issue and concern over the national security law. We saw that last November with the nearly unanimous support for this law that was passed. And that's important because it means that the balance of power in Congress is going to also impact what the president can do. The law that is being proposed aims to restrict the president, or at least force the president to address these issues through reporting. And so if there's a more hostile Congress, whoever the occupant of the White House is, then I think that will impact the president's hand in terms of the political price of acting or not acting on this issue. So a lot of balls up in the air around this issue. With that said, I will say that it's always dangerous to predict, and we were all wrong 4 years ago with respect to the election. So that's the risk that we deal with now.
Indeed. Well, thank you, Thomas So. Thank you, Tamara Solomon. Thank you all for joining us today, and we look forward to catching up with you again in the future.
Thank you.
Thank you.